US, and UK perspectives to round off the very good conference that we have been having. So I'm going to ask Paul Hoffman to start. Thank you, Paul.
Thanks. And I'm going to talk about primarily litigation in the United States under the Alien Tort Statute, which was a statute passed in 1789. So I have 10 minutes to deal with 220 years of jurisprudence. But fortunately, from 1789 till about 1980, there was nothing to talk about because there were no cases. So it's only in the last, actually, it's in the last 15 years that we've been litigating cases against corporations, corporate accountability litigation under the Alien Tort Statute, which allows non-citizens, aliens, to bring suits for torts committed in violation of the law of nations or treaties of the United States. And since the United States rarely signs any human rights treaties and certainly has no intention of fulfilling them, most of the litigation has been under customary international law. And all of these cases are cases, just to put it in, to situate this, I think, these are cases involving the extraterritorial activities of either U.S. companies or foreign multinational corporations. None of the cases have been about the operations of corporations within the United States, right? And the reason for bringing these cases has been the absence of effective remedies in the places where the conduct occurs, as a general principle. And so, in its context of Ruggie and the rest, what we see our role as litigators under the ATS in the United States is catalysts, or we're the club. If you don't do the right thing, corporation, you might get sued by that crazy person on Venice Beach. That would be me. And one of the things in terms of the other conversation is that, at least from my perspective, unless you have effective remedies someplace, effective judicial remedies, all of the other stuff is not going to happen. I think that the grievance mechanisms, all the voluntary mechanisms, will never be effective unless there's a club against the corporations if they don't do the right thing. So that's where this comes about. And what I mainly wanted to say in the short amount of time I had to talk about this is sort of where we've come in this process, because many of you know that the Supreme Court in April of 2013 decided a case called CORE versus Royal Dutch Petroleum, which I argued seemingly many times in front of the Supreme Court, actually only twice. And a lot of folks see that as the death knell for the kind of work that we've been doing. And I want to assure you in some ways that that's not true, that we're going to continue to bring suits. But in the last 15 or 20 years, these cases have been, to give you an example of the kinds of cases that have been brought, the first one was Doe versus Unocal, which had to do with a pipeline project in Burma, and it was a suit against a California-based oil company. We originally sued Total, the French oil company, but they got dismissed for lack of jurisdiction. And this was a joint venture with SLORC, with the Burmese military regime and its corporation. And similarly, there are cases like Presbyterian Church of Sudan versus Talisman, having to do with claims of genocide, crimes against humanity in South Sudan. There have been cases filed arising out of corporate support for right-wing death squads in Colombia. There were cases filed against corporations for complicity in apartheid. There are cases, some cases have been filed arising out of particular incidents of human rights violations. For example, the bombing of a village in Colombia with the complicity of Occidental Petroleum. So there's a range of cases. For the most part, and it's been interesting to hear the conversation about the different issues that people have dealt with, because we've dealt with all of those issues in these cases. First, do we have jurisdiction over the defendant? If it's a foreign corporation, we've had to deal with some problems on that. If it's a US corporation, we don't have that problem. Forum nonconvenience is sometimes a problem. Usually there are no remedies back in the home country, and so we haven't had too much problem with many of those cases. The big issue in most of the cases, at least, had been the question of aiding and abetting liability usually is the big issue for us. And it's also the way that we get around the corporate structure issue. It's a combination of aiding and abetting liability and agency is the way we have traditionally gotten around the questions of corporate structure and whether you could pierce the corporate veil. What we've argued is that the parent, through its agent, the subsidiary, has aided and abetted the human rights violations that have been committed, usually by security forces that the corporation is in bed with. And the big issue in the cases has been, what exactly does a corporation have to do or know to be found liable under either international law or domestic principles of aiding and abetting liability? And the fight had been largely about the mens rea that a corporation had to have. Was it enough for a corporation to know that its assistance was going to lead to human rights violations and therefore they became liable for them in some way? Was it enough to do business in a repressive regime? Generally speaking, not even the plaintiffs would argue that. Or did they have to have some higher level of purpose? And up until recently, there was some chance, or at least some cases, that found that knowledge was enough, and that knowledge was the standard under customary international law and also under domestic American tort principles, which were brought into the ATS. More recently, the courts have been going more towards the purpose standard of the Rome Statute, which is not to say that the courts actually understand what the purpose standard of the Rome Statute is, or sometimes even why they're applying it, since the United States hasn't even signed the Rome Statute. But what courts have tended to do in this area it's been more of a political response to the kinds of cases that are brought. They want to keep control over the litigation, and so they want to make it hard for plaintiffs to bring cases, and the perception has been that if knowledge was enough, it would be too easy for plaintiffs to win. I think that's at least my non-analytical perspective, but having litigated enough of these cases, I think that I'm right about that. But all of that litigation about aiding and abetting and all the fight about aiding and abetting and where liability is on this continuum has kind of been pushed to the side recently by the CORE versus Royal Dutch Petroleum. First, it was pushed aside because an appellate court found for the first time in 30 years of litigation under the statute that you couldn't sue corporations under the Alien Tort Statute, that you can only sue natural persons. And that was a hotly debated, it was a 2-to-1 decision in the Second Circuit in New York. That was what led us to file a cert petition to the Supreme Court that led to the decision that came down last spring. But our initial petition was about this question of corporate liability. And we were very confident that there was no chance that even this Supreme Court would rule against us on corporate liability. But of course, they were smarter than we were. And when we had our first argument in the Supreme Court, the justices immediately changed the question and said, well, why are you here? This reminds me, somebody else said the why are you here question came up in another case. Basically because our plaintiffs were Nigerian villagers, our defendants were Shell, which was both a UK and a Dutch corporation, and all of the events took place in Nigeria. And so the question was, well, why here in a US court should the court take jurisdiction over the case? And so the question was changed, and we were asked to re-argue the case in October of 2012, which we did. We actually also thought that we had a pretty good argument on whether the ATS applied extraterritorially, because all of the cases that had ever been filed under the ATS were extraterritorial. There had never been a case that I'm aware of where the Alien Tort Statute had been used to deal with events that occurred within U.S. territory. All of the cases were extraterritorial. There had never been a case that had said you couldn't use the statute extraterritorially. But now there is one. the Supreme Court in April of 2013 decided that the presumption against extraterritorial application of U.S. statutes applied to the Alien Tort Statute, which was odd in some respects because when Congress passed the statute in 1789, the presumption didn't exist. And usually the idea of the presumption is that the court should assume that Congress passes statutes with the idea that unless they make it clear, there's only domestic application of a statute. In this particular case, the court in a sense didn't say the presumption itself applied. They said the principles underlying the presumption applied. And there was a 5-member majority. Chief Justice Roberts wrote the main opinion in the case. And there are 4 sections in the opinion. The first 3 sections make it seem like there will never be an extraterritorial ATS case ever again in the history unless Congress changes the statute. And then there's this very interesting 4th section that says, well, if you look at an ATS claim and it touches and concerns U.S. territory with sufficient force, the presumption might be overcome. So it's kind of 2 parts of an opinion at war with each other. And the reason for that, I would submit to you, is that our Supreme Court is split ideologically pretty much right down the middle. And so you had 4 justices that would just as soon wipe the ATS off the statute books and consider it a historical anachronism. And you have 4 justices on the other side that want to try to find rules to make it work. Justice Breyer led that group in this decision. And he would have said, well, the presumption against extraterritoriality has no application here. Let's use principles of foreign relations law and international law to define the kinds of situations when it would be appropriate for the ATS to be used. But they also would have rejected this case, right? Because it was foreign cubed, everything foreign, not enough of a connection to the United States. What they said was, mere corporate presence of a multinational corporation is not enough to justify U.S. courts taking jurisdiction and deciding this kind of case. So, where do we stand now? We stand with Justice Kennedy in the middle, and what Justice Kennedy said in his concurrence was, there may be some other cases that come down the pipe that don't fit the holding of the majority, and at that point we'll have to tell you what the presumption means. But he wouldn't tell you what the presumption meant. He's kept all his options open. So whatever Justice Kennedy thinks is what the ATS means. And that's basically what it is. That's the legal principle that you derive at the end of the case, is that Justice Kennedy at some point in the future will tell us what this statute means. But in the meantime, until Justice Kennedy tells us that, there are 2 warring, there's a defense position on this and a plaintiff's position on this. Surprise, surprise. And the defense position on this is that the plaintiffs have already lost everything and they should go home and never bring another ATS case again because the Supreme Court's already decided this. The Second Circuit issued a decision about a year ago, a little less than a year ago, that basically laid out that kind of position. It was also written by the same guy that wrote the decision that said there was no corporate liability, and seems to be the judge that I get on every single case that I go up to the Second Circuit on. It's like, I think whenever I file a case and he sees my name, they put this guy on there and make sure that I can't cause any more trouble for anyone. And then on June 30th, so 2 weeks ago, the Fourth Circuit, which is in Virginia, a circuit which used to be the most conservative circuit in the United States, but since Obama has been president, he's appointed a bunch of new judges, so now it's shifted ideologically, has just issued an opinion in Shamari versus Khaki, which has to do with Abu Ghraib and contractor liability in Iraq for torture. They've issued a decision that said, well, this is a U.S. defendant, a U.S. citizen defendant. The torture took place in a U.S. military base with U.S. military people involved. How could this not touch and concern the United States? which is basically what we've been arguing in a lot of other cases. And so you've got one opinion that basically is the most conservative you could get, and you've got another opinion now which lays out the case in the way I think it ought to be laid out, but certainly I have an interest in this, on the other side. And you have a bunch of other cases going up in the various circuits around the country. There are 3 cases in the Ninth Circuit in California that have gone up. There's one that I just argued a couple of months ago in Miami in the 11th Circuit involving Doe versus Chiquita, which involves a U.S. company that's made payments to right-wing death squads in Colombia. And so we're stymied. We haven't even gotten back to all these other issues like corporate liability or aiding and abetting until we get over this extraterritorial limitation. And you know, we just don't know. The cases probably will split. The Supreme Court will probably have to decide them, or one of them. Hopefully it'll be a U.S. contractor case or something like that, because those are the strongest, I think. And then we'll find out what the rules are. In the meantime, though, we're starting to think about new avenues of redress. And for example, we have, in many of the cases, had claims under state law or foreign law, but they have been very much subsidiary to the Alien Tort Statute claims, in part because of something that was also said on the first panel, which is that under the ATS, you get to call the violation what it is. You get to call it torture. You get to call it extrajudicial execution. It is the human rights violation. It's not a tort of battery. It's not wrongful death, which for our clients doesn't sound very good. And there are other limitations to that. But if that's what we have, that's what we'll do. And the other thing is we have a statute called the Torture Victim Protection Act, which has been interpreted, it only applies to torture and extrajudicial execution, but it is explicitly extraterritorial. And it doesn't apply to corporations, but it does apply to corporate executives. And so if any of you know when a corporate executive from some of these really offending companies is coming to New York, we would like some advance notice of that, because when they go out to dinner at their fancy restaurant on the Upper West Side and they get their bill, they might get a complaint served on them. I think that would be really special. So we're thinking about things like that, and it's thoughts like that that get us through these dark times. And there are also some other specific statutes. For example, we have a statute about trafficking, labor trafficking, sex trafficking, that's explicitly extraterritorial. And so a lot of folks that have been doing the human rights cases are starting to do more cases in the trafficking area and trying to build up the jurisprudence there. There are anti-terrorist statutes that people are looking at. In the Chiquita case, for example, the United States government brought a criminal prosecution against Chiquita for the same payments under an anti-terrorist statute. Well, the plaintiffs can do the same thing. I mean, these were, in a sense, terrorist acts under the statute, and we'd prefer to call them human rights violations, but if we have to put it within the statute, we'll do that. And there are some other statutes where I think folks will look at it. I think the bottom line of all this is that the demise of the human rights litigators and corporate accountability litigation in the United States it's a little premature, I would say. And I think that because there's a movement for corporate accountability, which I think is reflected by the number of people and the interest in this room, as long as there's a vibrant movement for corporate accountability, I think you're going to find litigators, at least in the United States, that are going to be willing to support that movement by bringing cases against corporations and their executives for the kinds of actions that you've heard about today, and we'll find ways to hold them accountable. So, thanks.